Hello, and welcome to Thinking Boldly. This is the podcast series for the Concilium Institute. And I am retired Judge Julie Field, and I am here with the co-founder of the Concilium Institute, Heidi Webb. And we are thrilled today to feature our special guest, Justice Melissa Hart. Justice Hart, thank you so much for joining us today.
Thank you so much for having me. I'm honored to be here.
Well, let me tell the world a little bit about you and how when I say that we're thrilled to have you here, we really are. I had the privilege of meeting Justice Hart before she was Justice Hart, when she was a law professor at University of Colorado at Boulder, and would come and try and cram into our brains as judges at the judicial conference in about an hour all of the Supreme Court and constitutional law issues that had come up in the prior year. So that's when I first got the opportunity to meet Justice Hart. But she has served on the Colorado Supreme Court since 2017. And before joining the court, as I said, Justice Hart was a professor at University of Colorado Law School, where she directed the Byron R. White Center for Study of American Constitutional Law. Throughout her years as a professor, Justice Hart maintained an active pro bono practice, which is amazing when we think about the brilliance that you've brought to those cases. You were writing amicus briefs in appellate courts and representing clients through the Metro Volunteer Lawyers. Your teaching and scholarship is focused on access to justice, constitutional law, judicial decision-making, legal ethics, employment discrimination, and civil procedure. Justice Hart is a Colorado native. She grew up in Denver, where she graduated from East High School, and she earned her bachelor's degree from Harvard Radcliffe College, and then spent a year teaching at a high school in Athens, Greece, which we may have to ask you a few questions about that. She returned to study at Harvard Law School, where she was articles editor for the Harvard Law Review and book review editor on the Harvard Women's Law Journal. After graduating from law school in 1995, she clerked for Judge Guido Calabrese in the Second Circuit Court of Appeals and for Justice John Paul Stevens on the U.S. Supreme Court. Justice Hart practiced law for several years in Washington, D.C., including as a trial attorney in the U.S. Department of Justice. And Justice Hart and her husband, Kevin Tarascos, have 2 children and 2 dogs. So, Justice Hart, we are so excited to have you as part of our conversation today.
Well, thank you. I really am thrilled to be here. I am thrilled by the work that the Concilium Institute does. So this is just great.
Well, thank you. Thank you for supporting what we're doing. And one of the reasons we really wanted to spend some time talking with you and feature you on our Thinking Boldly podcast is because you really, in my view and in my experience, as a trial judge and now as the co-founder of the Concilium Institute, have taken a huge leadership role in our state in family law issues. And I guess I'd like to understand, as a constitutional law professor, it doesn't necessarily seem like the most obvious fit. So how did you come to be so passionate about family law issues?
There are probably a lot of different reasons. Some of them are personal and, give me a call sometime and we can talk about that. But I really think actually, if you start looking at access to justice issues, you can't not care about family law. 75 to 80% of the family law cases in our state and in the country involve unrepresented parties who are struggling to make their way through court on their own. We've made the system impossibly complicated, unnecessarily complicated. And we have an obligation, I think, to that 75 to 80% of parties to make it less complicated. And even for those people represented by lawyers, and this is why I really like what Concilium does, I think we have an obligation to really try to get people to think about the fact that it doesn't have to be a fight. That
Mhm,
what you're trying to do is you're trying to get through this process together, especially when you have children, but even when you don't. You're trying to get through a process together so that everyone can get on the other side. And that's all. And uh, I, all of us who are lawyers were trained that our system is an adversary system. And so
mhm,
we kind of start with that premise in
mhm,
mind,
mhm,
and um and then we impose that on these unrepresented parties. So again, coming back to access to justice, we ask these unrepresented parties to figure out how to fight with each other in front of judges when they have no idea what the rules of the fight are. And then we ask the represented people to fight with each other. And so I think again, for me, the gateway drug was access to justice. That was really where it started for me. But the more I thought about it, um, I'm very passionate and I do tons of work around access to justice, but I've also become, I think, equally passionate about family law, whether it involves unrepresented parties or represented parties, because I just feel like we can be doing this better.
mhm,
We can just be doing this better. And we should be doing this better. And I think one of the incredible joys of my job as a Supreme Court justice is that I get to think about how we administer the justice system. And so I get to think about, okay, well, what if we didn't always have such an adversary system? What if we
mhm.
thought about ways to make it less adversary? We have that power. And that's very exciting to me. And I just answered for way too long, but
No, I
No.
love,
that's
love,
very
love, absolutely love hearing you say that. It's so aligns so deeply with my own thinking. And Julie's heard me say this a million times, when I was thinking about concilium and sort of started with, asking what seemed like a pretty outrageous question, and just sort of thought, what if English contract law weren't the basis for this? And why is it? It seemed like it was almost like, can't I ask that question? And it seemed like maybe I couldn't, but I did. And hearing you say that from your position, it sort of reminds me in a way of the bumper sticker we used to see that said "Think global, act local." It's like
Right.
but you're really taking these big concepts
Mhm,
that are not convoluted to people who understand the rules, but it's sort of we throw people into a boxing ring with no experience, or and just expect them to sort of go at it. And I can only imagine as judges how frustrating that must be to sort of watch this unfold. Um,
well. And am I allowed to call you Julie or should I call you?
Please, no. Oh, gosh, no, please, of course.
I was never a trial judge, so I never sat on a divorce case, but you did. So you saw the way. I mean, again, for the unrepresented people, I feel like we're asking them to fight in without any boxing gloves, sort of.
Right.
But then
Right.
the represented parties, they're already so angry,
Yeah.
and we're like, "Come on in and just get
Go
it."
at it.
And
Right. Right.
and I
Right.
imagine as a judge, it must just be really hard because you want to say, "Can I bring the temperature down?
Right.
Can I help you not be this angry?"
Mhm,
It's almost like, the system probably is good for 5 to 10% of the people, but we throw everyone in there and apply
mhm,
it instead of
right.
sort of having a system that more broadly works. And then for the exceptional situations, we sort of have to use this other system.
Right.
But to
Mhm.
hear you talk about it from your perspective, where you have the ability to really craft something that has that impact, is just so powerful.
Mhm. Yeah, and, I always was thinking when I was on the bench, 2 things. One is my goal was always to have a family be self-governing after divorce, right? That was my goal. Give them the tools that they need, right? So that they didn't have to come back and see me. But the second thing that always struck me, having taught trial practice in law school, was in trial practice, we're looking at past events and deciding what happened.
Right.
In a family, we're trying to figure out what will happen
Right.
and what it will look like. So it really, you're right, Justice Hart, it really is not a great fit for how we now think about families.
Well,
And yeah,
exactly. And I know one of the things that you want to talk about is our proposed Colorado rules of family procedure.
absolutely.
And I would
Yes.
say it's been so interesting working with this incredible group of lawyers and judges who's been working on developing the Colorado rules of family procedure. And essentially what we're trying to do is pull family law out from the rules of civil procedure.
Mhm,
And I was not it was actually Judge Randy Arp from the First Judicial
mhm.
District who said to me as he was retiring, he he said, "Justice Hart, as the liaison to the section on family, uh,
Oh, the standing committee?
Money
Yeah.
Committee on Family Issues," he said, "Would you please make this happen? Would you please try to make this happen?" And I said, "Sure, Randy, I'll do that."
And you are.
And it has
And you did.
and it has now become this complete passion project for me because once you start looking at how absolutely incorrect the rules of civil procedure are for family law, it like boggles the mind. Like there are no plaintiffs or defendants in family cases, but
Right.
there are only plaintiffs and defendants in civil cases. Like it's so, and that's just one like easy
Yes.
to describe idea.
Mhm.
So many things about the civil rules just don't make sense, and it goes to what Julie said. The civil rules are designed to look at an event that happened
Right.
and take account for it. And
Yeah.
Mhm.
and what you're trying to do in a family case is reorganize a family and
Right.
Right.
help them come to something that's gonna work for them.
Mhm.
Right. And the
And
language.
that's just completely different. And
Right.
so
I love hearing you talk about the language because I think, the words we use obviously, indicate the thoughts we have or they express the thoughts we have. And when we start from a premise of a plaintiff and a defendant, like you said, it's an adversarial system, it's an adversarial setup, and you sort of can't but avoid posturing that way.
yeah,
And, when you talk about mothers and fathers or co parents or things that are conducive toward restructuring a family in a way that has sort of hopeful outcomes, it's a very different premise, right?
absolutely. And one of my favorite things about our proposed rules of family procedure, which again, they have not been adopted yet. The court hasn't voted on them yet. You can probably tell how I'm going to vote, but
Well, you worked really hard to make them happen. So, yeah, I
but
would hope that you would
yeah,
support them.
So
they
eager to
have
see them.
they haven't been adopted yet. One of my favorite things in them is uh what the family law section of the Colorado Bar Association has very wisely told me we need to rename. It has been called the informal domestic relations trial procedure, which they started calling I-dirt.
Oh, God. Oh, man.
I know, so mad, so mad.
So bad.
You gotta think acronym when you title something. You really have to. You have to think
Not
ahead.
have a good branding and marketing department.
Yeah, so I had a really great meeting with the chair of the of the family law section, and he mentioned me, and I said, "Oh my gosh, that was certainly not
So funny.
that was not anyone's intention." So I'm hoping that ultimately it will be called the informal family pr- trial procedure, or it's, something that can't be called IDIRT.
Right, 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 right.
I love it.
But what it is it's the presumptive process under these rules, if they get adopted. It's the presumptive process that would be used for unrepresented parties.
Mhm.
And the judge, in fact, it's more the European system, what they call the inquisitorial process rather than the adversarial process. So
Mhm.
the judge will ask questions. There won't be formal rules of evidence. The parties will come in and say, in response to the judge's questions,
Yeah.
what are you looking for here? What do you need?
Love this. Yeah.
Parties will be able
Mhm.
to answer instead of
Right.
this idea that there would be cross-examination, which
Mhm.
parties don't know how to do. The parties will just talk to the judge and say,
Right.
here's how we would like to resolve
Yep.
our situation.
Mhm.
Here's how we think we should work things out. And the judge can decide that.
Right.
And there are already a lot of judges who frankly do that.
Mhm.
But there are, yeah, yes, exactly. But, but there are a lot of judges who are less comfortable than Julie was when she was a judge
Sure.
with that authority. They feel as if I have to follow these rules that I learned in law school.
Right.
Well, and
And
from a judge's perspective, I mean, I would talk with my colleagues about doing something more informal, and the folks that came up either through a civil background or even a criminal background, especially, right, which was most of my colleagues. I was the only family law experienced person
Right.
when I was on the bench when I was appointed in my district. It felt uncomfortable doing that. And part of, and I'm going to turn that back to you, Justice Hart, because part of that concern about and discomfort on the part of the judges is, what is the Court of Appeals going to say if they see this transcript, or what is the Supreme Court going to say? And so, what guidance does that, given that the rules are hopefully changing, and how will that help empower judges?
Well, I think just having a rule that says this
It's
is
okay.
allowed to
it's
happen,
okay.
Yeah.
Right.
that itself will
Mhm.
be
Yeah.
a huge empowerment for judges.
I
Mhm.
think
That's what
that
I'm hoping. So
mm,
Mhm.
it's messier. And I think that there are a lot of people who are comfortable in, having a system that you can apply, like the rules of civil procedure. And I think, all of the family law, sort of the complexity of it can be messy. And I think when you see sort of trial lawyers, I guess there's sort of a business model that also this works for, right? There are people who make their livelihood by being great family law litigators. And they want to apply these rules and they want to object to certain evidence being introduced. And I mean, that's part of the model,
That's our training.
right?
That's our training.
Right.
Yeah.
And you can't fault somebody for that. I mean, that is what you've been told is good, in fact, expert lawyering. So, I think when it comes from the Supreme Court, that this is a change and it's a cultural change. It's not just a rule change. It's really asking people to revise their perspective and the paradigm that they use for how we approach helping families move forward.
I yeah, absolutely agree with that. And I would say one of the things that I hope uh will make this change palatable, not to everyone. There are going to be people who will say, I hate this. This is a terrible idea. What is happening? But I just pulled up, or not just before we started talking, our sub. Uh, we have, um, like, I want to say 6 members of the CBA family law section on various subcommittees. We have at least 6 judges on different subcommittees. We really, really tried to engage people who are actually involved in the practice of family law,
Mm.
to say, does this make sense? Like, what changes make sense? What things should we just keep? Like some rules of civil procedure, we just said, this makes sense. Let's just keep it.
Yep.
This doesn't
Yep.
make sense. Let's change it.
Love that.
Right.
Like, so it was not kind of a wholesale, let's just change
Sure.
everything. It was a
Right.
very,
Mhm.
Right.
I think, an extremely thoughtful process of what does a family law case really look like. So,
Right.
for example, one of the things that is proposed is some pretty significant changes to some of the timelines, because
Mhm.
um, a lot of the judges said we're ending up having to continue hearings constantly
Yep.
because of the way the timelines are set in the rules of civil procedure. They just don't work with how domestic cases are set up. And so we sort of worked backwards from, okay, let's think about how a hearing is set up, and like, let's think as domestic practitioners and work with that, which nobody has ever done.
Right.
Mhm.
And you guys may definitely want to cut this, but I'm just going to say I taught civil procedure for 12 years. Um, and obviously I went to law school, so I learned civil procedure and I've read our rules of civil procedure. This concept of one form of action, that there's one form
Mhm.
of action,
Right.
in 1938, when the federal rules of civil procedure were adopted, that concept was adopted. And the states, including Colorado, carried that forward. There shall be one form of civil action. It's not true anymore. Um,
Mhm.
we recently, well, we haven't adopted them yet. We have a hearing next month, I guess, in April, on our rules of our juvenile rules.
Right.
Like, it's, I think what we've recognized in modern times
Yeah.
um, is actually there shouldn't be one form of action.
Mhm.
And I think this is just part of that recognition. And so the rules of civil procedure are going to have to be amended to not say there's one form of action. Um, because these cases are different and they just need different things. And we can't ask the rules of civil procedure to change to fit family law
Right.
because
Right.
they
Right.
work
That.
okay for complex civil litigation.
Yep. Yep. That makes
Instead, we
sense.
just need to adjust. So,
Right.
So are you looking at the juvenile court rules as well? That's
my court is. That's not something I'm
recording.
involved in, but my
Okay.
court is. Yeah.
Mhm.
I mean, I'm involved in it to the extent that all seven of us are involved in it, but it's not something I've.
Yeah.
You're not spearheading that.
Right. Right.
Yes. You've had
Still
enough
looking up
spearheading.
right. I know, I get that. I just mean there I would also think that they're, you know,
But yeah, they've
timely.
been working on that. So, and one of the things that I've received some criticism for. They've been working on the juvenile rules for 5 years,
Mhm.
and when I decided to take this on again at Judge Arp's request, I talked to some judges in Arizona where they do have a separate set of family rules,
Hmm.
and they said we gave ourselves a 1 year, like,
Deadline.
we're just going to do it because you could
Mhm.
you could take forever.
Right.
Uh, and so when I put together this committee, I said we're just gonna do 1 year. It was 18 months, but but I
Still.
just said we're not. It's not going to be 5 years. We're not
Mm.
going to do that.
Right. No, that actually was something I wanted to remark on is the speed and in which this was done and the complexity of it and just the leadership that you've shown in getting this to towards the finish line. It's not quite there yet.
And
So
it's
I
not
did
there
want
yet,
to,
but yes.
yeah, but I did want to ask about that timeline because we want this podcast to be an opportunity for people to understand what the next steps are. And I wanted to talk with you, especially before your public hearing on the rules. So if you want to just outline that, we'll have a link also for folks to be able to access the rules and to be able to give feedback in along with the timelines that you've set out. But if you want to just summarize that for
Yeah.
us.
And gosh, we really want feedback. Like, I desperately want feedback, because what's going to happen? So April 25th is the deadline for submitting written feedback.
Mm-hmm.
And we really, really want it. Like, we take it extremely seriously. Because I've been so involved in this, I will then spend however much time it takes to go through all of the written feedback and kind of incorporate it into a red line of the rules and send that around to my colleagues. We then have a public hearing on May 13th.
I think it is May
I
13th.
think it's May
Yep.
13th.
Mm-hmm.
And what I anticipate after that is that we will send it back to the subcommittee. And again, this is the subcommittee of the Standing Committee on Family Issues. We will send it back to the subcommittee and we will say, can you take a look at these proposed changes? And I know, again, I mean, there will be individuals who will have proposed changes, but I do really, really want to call out the family section of the Colorado Bar Association. They've have had one, I think, and then are going to have two more, like, section meetings where they're really going through the whole set of rules and they're proposing specific changes, and like, that will matter a lot to the
Mm-hmm.
court, a lot.
Mm-hmm.
And so we'll send all of those to the subcommittee and say, can you get something back to us that where, I mean, you may disagree, the subcommittee may disagree, although again, a lot of the members of the subcommittee are on the family law section, so I'm guessing they won't. And then we'll vote ultimately. So
Mm-hmm.
that's kind of what the process will look like.
Mm-hmm.
With one big caveat, we then either have to we're going to have to do some kind of a workaround, because the legislature isn't going to have the time or emotional energy to do an amendment to Section 14, Title 14, where it references the rules of civil procedure. So
Mm-hmm.
uh, I'm not gonna opine on what we might do, but we'll probably have to do some kind of workaround, unless we want to wait a whole year to have
For the
them
next.
take effect.
Right, for January,
Yep.
right, to come back in January. Right, we don't want that. We want this to go in effect as fast as
Would be better to have
possible.
it happen. So,
Right, exactly.
we'll figure it out.
Yeah. So there's other initiatives, though, that you've been working on and leading across the state, including the summit the Family Law Summit that we recently had last month with the Bench and Bar Summit, and sort of bringing those conversations together, which is one of the pieces of your leadership that I really, really admire and think is so strong in the family law area, where you've really been working to bring together the bench and the bar.
That makes us awkward. Thank you. I'm not great at that, but thank you. I mean, I do think it's super important. I think it's really important for us to be talking together and working together and kind of breaking down assumptions. Because I think there are a lot of unfounded assumptions. And just misunderstandings. And if we can just talk to each other more, um, everything's not going to get fixed. Like, one of the things we didn't talk about, or I don't think we talked about at our last summit, was the chess clocks.
Oh, you're right. So Heidi's looking a little curious. The chess clocks are the time limits that many judges, including myself when I was on the bench, put on the parties so that the case wouldn't go on and on and on and on for days and days and days, right? But Um,
and which lawyers say, and I, again, not having been a trial judge myself, I've never used a chess clock, although we do, of course, have timers, but not
right.
chess clocks. Lawyers say it's embarrassing in front of my client. It like my client looks at me and thinks I'm a child who's being kind of like patted on the head by the judge. And judges say, well, I have to have a way to make this hearing run on time. And and that was one of the things I really wanted to talk about at that last meeting was could we is there some way to find some kind of middle ground, because I both of those things sound super reasonable to me. So like it just seems to me there's got to be some place in the middle that we can meet. And we just didn't have a chance. We talked about so many important things and we just didn't have a chance to talk about that. But I thought uh, there was an appreciation of each other's humanity that
Yes.
maybe we'll
Hmm.
make it easier to talk about the chess clocks at some point in the future, which I think would be really important. And that's my goal with all of this is I love all of the judges I know who do work in this area. And I I don't know the lawyers as well, but I really like them too. So I feel like if we could spend more time just knowing each other as people,
People.
that it would make a huge difference. And then it wouldn't make people so mad about the chess clocks. Like we could just talk about it. So that's my
Right.
I I, I sound
Well, and
crazy lefty person, but that's
no, 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 no. I hated the chess clocks, but I felt like I had to use them, right? And
How are you
uh,
spelling that word?
chess,
Chess. Like chess.
chess, like a chess clock, like
Got it. Like you're
play. Yeah, one side. Yeah, yeah, go. Yeah,
like read.
yeah.
Done.
Right, exactly. Um, yeah, so figuring out that balance and hopefully some of the changes in the rules of not civil procedure, but domestic procedure.
family
Well,
family procedure.
family.
Calling it
Oh, love it.
our
Love it.
parents
Yes,
call it family procedure, but
family procedure will help alleviate some of that need, right? Because it will give the court a sense of more control
space.
over,
Yes, I think
yeah,
that's right.
the process,
I think
right?
you should be right. Yes,
Yeah.
that it's definitely one of the hopes.
What about
Mhm.
family restructuring process?
And renaming the rules to that. I think it may be a little too late at this point, but you could put that comment in, Heidi.
Yeah, you could put that in. I think that might be too radical for.
Family restructuring procedures. I
Yes.
don't know.
So one of the things about the Consilium Institute and our Tapestry membership is that we are growing across the country. And so one of the things that we're finding is the cross pollination of people in different jurisdictions. And it sounds like you drew at least some of the guidance for the new rules from Arizona and from other lessons learned from other places. So
Ab-
what
Absolutely.
what are some of the strengths that you've seen in those other places, and what do you think we can, as people in the trenches, can learn from other places?
Oh my gosh, so much. I mean, I occasionally just get on Google and start Googling around because I like there's just so much innovation happening everywhere. It blows my mind. So I mentioned earlier the informal eye dirt,
Right.
the informal family procedure, which we really, really borrowed from Alaska. And it's been really successful in Alaska. And so we
Right.
started with Alaska's procedure. And uh, a very similar procedure is being used in Cincinnati. So not all of Ohio, but Cincinnati, uh, and maybe Des Moines. I don't quote me on that, but there are a couple of other local jurisdictions. Alaska's the only other state that's doing it
Mhm.
completely. But like people I feel like there are people everywhere looking at these problems because again, this 75 to 80% of family cases that are unrepresented, that's not just Colorado, that's everywhere. Right. And
Mhm.
so every state is looking and saying, what can we do to support this population? Um, Obviously, we're not going to pro bono our way out of it. We're not going to, we need to support these people who are unrepresented in getting them through the system. And frankly, we need to support the judges who are
Mhm.
having to handle these cases and getting them through the system. We need to support their children who didn't get to choose any of
Mhm.
this and
Yeah.
getting them through this system. And so I think right now, there's a huge energy for innovation in this area. That's one of the reasons that we adopted our licensed legal paraprofessionals rule,
Mhm.
which is only in family law, but
Right.
may expand, but right now it's only in family law, and it's absolutely because we recognize we need to help people who are trying
Mhm.
to deal with restructuring their families, and we need to
Right.
provide them whatever solutions, whatever tools we can. And I think all over the country, people are looking at this. So I believe, Arizona has rules of family procedure. I believe they don't currently, I think, have an informal procedure, but I think they're looking at it.
Mhm.
I'm in touch with a number of judges there. And last time I talked to them, my understanding is they're looking at one.
Mhm.
Um, Trying to think who else I'm in touch with a lot of judges around the country on these issues, and there's
Mhm.
just a lot of conversation.
That's
Yeah,
A lot of
which is
people
good.
so
are
great.
talking
That's
about
so
this
great. Yeah.
because there's just such an urgent need. That's all. There's just such an
Mhm.
urgent need.
Yeah.
Yes.
Yeah.
I think Oregon might be looking at an informal procedure.
Mhm.
I mean, everyone recognizes that we can't keep doing things the way we've been doing them. We can't.
Right.
Yeah.
Right.
Yeah.
Yeah.
So,
Yeah.
and we need to be thoughtful and creative and also talk to each other and learn from each other
Mhm.
about what works.
Yeah.
So,
Well,
Yeah.
that's so encouraging to hear. I mean, that's just incredible that there are these, it's sort of like it's a movement. It sounds like it's happening. It's ground
and
up.
it's
Mhm.
fun. It's really fun to talk to other states. And also it's a real learning experience because there are states where their legislature is more involved than ours. And there are states where there's less local control than there is here. So, I mean,
Mhm.
there's sort of, you realize, okay, some things are easier to get done here because we definitely have what I think every state should have, which is the courts control the courts. And then some things that are harder because we have such a strong local control culture. And so we have to
Mhm.
figure out, okay, how do you balance those things? And
Right.
what the local control culture means is you have to bring people along and convince people that this is a good idea. You can't just tell
Mhm.
them you will do this. You have to convince people this is a good idea.
Right.
So
Right. Well, and I'm glad you're the one helping to do that convincing because you're obviously very caring, passionate, persuasive, and amazingly um,
Knowledgeable
uh,
and informed.
not yeah knowledgeable, informed, and quick on your feet. Which actually leads me to my next question, which is I told a former law clerk of mine that I was going to be speaking with you, and she said, "Well, you need to ask Justice Hart
oh, this is the
about
surprise.
when she was a guest on Wait, Wait, Don't Tell Me."
Oh my goodness sakes.
tell me about Wait, Wait, Don't Tell Me and what that was like to be a guest on that NPR show.
Oh, that's so funny. So that's so funny. So my family and I used to listen to Wait, Wait. I'm an empty nester now, but, but my family and I used to listen to Wait, Wait, Don't Tell Me every Saturday, which everyone should do. It's so
So
fun.
great.
Um, and I can't think why we were driving down from the mountains on Saturday morning, but we were. And my son, who was probably like 6 or 7, it said, if you want to call in, call this number. And so he grabbed my phone and called in. and and just so anyone knows, if anyone wants to call in, it's not like they answer. It's so, but he called in and he handed me the phone, and I left a message saying I live in Denver. I would be interested in being on the show. And so they called me back, and they said, which section, which piece would you like to be on?
Right.
And I ended up being on the limericks section, which probably wouldn't have been the one I would absolutely have chosen, but the timing of it worked out the best. And also, I frankly think it's the easiest. So
It is the
I
easiest one. I think you're right.
confident that I would not fail, which seemed quite important. Yeah, so it was fun, and what was most fun about it, honestly, doing it was fun. But what was most fun about it was all the people I got emails and calls from afterwards who I hadn't heard from in years, who
So
listened to
funny.
me Don't Tell Me all over, not just the country, but the world, who were like, Melissa, I heard you.
That's great. And now the follow-up question was, did you ever get the voice on your answering machine?
No, I never did. I never did. I should have, but I was too disorganized to do that.
Yeah. I wonder if the statute of limitations has passed.
I have won the opportunity.
I have totally wondered if I called and said, hey, I was on a long time ago. Could I please have your voice on my voicemail? But that feels weird. So,
you won the opportunity, and if there's not a statute of limitations,
yeah, I would call. I would call.
Well, it was fun regardless of the whole voicemail thing. It was just fun. And it was also just so sweet that it was my son who was like,
love that.
Do this, Mom.
Right.
That's fantastic. Well, thank you for being our guest and stepping down from your national spotlight on Wait, Wait, Don't Tell Me to come and talk on Thinking Boldly. We're just so thrilled again that you took the time this morning, Justice Hart, to talk with us about the important rules changes that are coming and all of the work that you've been doing and your leadership. And we're just so appreciative of everything that you're doing to help families restructure in Colorado. And I expect that Colorado will prove to be a bellwether in terms of family restructuring, and that the rules that you've worked so hard on and so quickly but beautifully on will become a model for other states.
Well, thank you. Thanks.
Certainly love
both of you. I really
certainly love to be able to bring the conversation to Massachusetts. And I think we need a sub title to our show now, which is Wait, Wait, Do Tell Me.
Excellent. Yes, excellent suggestion.
Thank you both so much. Thank you for everything you're doing. I really appreciate it. It's so important. So,
well, thank you. It's been a pleasure.